Hello, my true crime lovelies. Oh my goodness, don't let this dimple fool you because I'm hopping mad. What did Judge Kraynick tell James Owens on Friday? What did he say? It's even in the court notes, the minutes. 11:59 on Friday, 9:27. Any suppression motions were due. We are also now, it's September 30th. It's 5:21. I got to go get Sugar Bear, but this just dropped. Thank you to the member who hit me up. So, yeah, it's 10 days within the first day of the hearing. I'm just hopping mad. I don't even want to be Judge Kraynick right now because well, you know what? He's cool, calm, and collected. Maybe I should channel my Kraynick, because maybe he'll just be like denied and hopefully sanctioned. Okay, what am I going on about? James Owens, he amended the suppression. I haven't read it yet because I wanted to read it with you. And let's be honest, I'm trying to be mindful of my time because I have to get out of here. This is what we have going on. He filed it earlier at 4:39:33. Like I said, I'm just now pulling it up because one of you guys left it in the comments. And so this is ridiculous. Amended motion to suppress defendant statements at Orange County Sheriff's Office comes now. The defendant by and through the undersigned attorney pursuant to Rule 3.190 Florida Rules of Criminal Procedure, the Fifth and Sixth Amendments of the United States Constitution. You know it's deep when we going back to the Constitution, y'all. Article 1, Section 9 of the Florida Constitution, and respectfully amends this motion, moving the court to suppress all statements made by the defendant during her interrogation at the Orange County Sheriff's Office, and in support thereof states as follows. 1, the defendant, Sarah Boone, is charged by way of information with a single count of second-degree murder. 2, on or about February 25th, 2020, the defendant called 911 in response to finding her boyfriend, George Torres, deceased. Number 3, Deputy Kayla Rodriguez of the Orange County Sheriff's Office, arrived on scene with her body cam activated. Upon arrival, Deputy Rodriguez spoke to the defendant and realized a death had occurred. Deputy Rodriguez advised her superiors and secured the scene. Number 4, sometime later, homicide investigators Chelsea Connolly, aka Chelsea Copsell, and Scott Lowen arrived. These two investigators would ultimately be responsible for this homicide investigation so this is pretty similar to what we read last week, except for the beginning where he's citing the Constitution and Florida Supreme Court, but this looks the same. The defendant was ordered to remain on scene while the OCSO conducted their investigation. I did not hear her order to stay there, but also he's adding this extra, well, let me just get through it because now it's all in one document, but let me read this and then I'll have my thoughts. As ordered, the defendant stayed outside of her apartment for several hours until the investigation was completed. She was told that she could not enter the crime scene, but you see how he's saying she had to stay out of her apartment. Well, because her apartment was the crime scene. So she was not treated unfairly. Like that's standard practice. At some point, the defendant was told to get into an unmarked vehicle with Detective Copsell and Detective Lowen. Once inside, Detective Copsell recorded an interrogation with the defendant after partially reading her Miranda rights, omitting the final question. Now, I feel like Judge Kraynick has already said about the Miranda rights that the waiver is BS, but here we go again. Let me channel my Kraynick. Or should I do like this? Anyway, so there's no recording, so I don't know if she was told to get in the unmarked vehicle or asked to get in she certainly had the right to say no because she wasn't in custody at that point. The defendant was advised this recorded interrogation was routine protocol and official procedure for any death investigation. If she was or wasn't is irrelevant. If it was true or not is irrelevant. The police are allowed to lie to you. During the investigation, Detective Copsell asked to see the defendant's phone. The defendant told the detective her phone was on the kitchen counter in her apartment. The detective brought the defendant her phone and instructed the defendant to unlock it. So we hear none of this on the recording. The defendant complied with the demands of the lead investigator. After Detective Copsell had the defendant's phone, and I think he uses lead investigator to indicate like she was the authority on scene. Okay. No, get down, Liberty. After Detective Copsell had the defendant's phone for a period of time, she came back and told the defendant that she was taking her phone. Detective Copsell asked the defendant to sign a form releasing it to the OCSO for further investigation. The defendant acquiesced to authority and signed the form. Bullshit. Sarah hasn't acquiesced to anybody since she came out her mother's womb, and she probably came out kicking and fighting then. The defendant was told that one of the detectives would return her phone to the defendant at her apartment in Winter Park the following afternoon. Again, if it's true or not, and did Sarah agree to it knowing she wasn't going to be there? She was going to be somewhere else? All of that is, I'm calling BS on it. Later that evening, the defendant moved to her ex-husband's home, Brian Boone, for the night. Using her ex-husband's phone, the defendant called lead detective Chelsea Copsell on her cell phone to express her concern that Detective Copsell was not being truthful about law enforcement motives as it relates to the defendant. The defendant told the detective she believed they were trying to trick her and being sneaky about something. That was the time to contact a lawyer. You had already been read your Miranda rights, Miss Boone. If you thought something was up, call an attorney. Or they told you could, sorry, am I yelling too much? They told you could ask and one would be provided if you could not afford one before and during questioning. The detective assured the defendant that they were not trying to trick or implicate her, but that the following day, the defendant needed to drive to the Orange County Sheriff's Office to retrieve her phone. This is, even if it's a lie, it doesn't matter, but it's not true because around 2:00, they knew that they were going to have that phone kept. And so that's when they filed for the search warrant on the 24th. So there's no way someone told her, oh yeah, we're going to give it back to you. Like they had the suitcase videos. They knew they were there by then. The detective explained that the reason for the change in plans was because she was pregnant and not feeling well. While under the, for being pregnant. So I just don't think they told her that. Anyway, had the defendant arrived at the OCSO to retrieve her phone and had questions about this tragic event. She had questions that were written down. So one, she intended to talk to them. In order to talk to them, they had to read her again her Miranda rights, right? Her Miranda warning. And the first question on her list was, when am I getting my phone back? So if you came down there to get your phone, why is that number one on your list? It's as if you knew you weren't getting your phone. That's so odd. A judge had signed a search warrant for the defendant's phone just 9 minutes before she arrived at the sheriff's department. Now, that is correct. But again, before they had her, that she had signed an affidavit and she had given consent. As soon as they saw those videos, they stopped and applied for the search warrant. The search warrant, I actually thought it came in 9 minutes after she arrived, but he's saying before. Either way, they did not have to give her phone back. And maybe they were stalling until the search warrant came back because the verbal approval or the written approval could be rescinded. And so they needed like hard, fast, this is ours documentation. While still under the impression that she was retrieving her phone, Detective Lowen led the defendant upstairs into an interrogation room. Detective Lowen wore his firearm on his waist during this entire event. A custodial interrogation ensued. I'm going to say, based on Sarah's body language, she was not worried about that gun because she popped up several times and he was like, sit down, please. Sit down, please. She was never like, oh my God, the big detective has a gun. A custodial interrogation ensued. Immediately after the interrogation, the defendant was formally arrested and charged with the offense above. This approximate 2-hour interrogation was recorded. I hope Judge Kraynick has read this by now. The initial dialogue between Detective Copsell and the defendant, Sarah Boone. Detective, I'm going to have you sit in the green chair. Appreciate you coming in. Sarah Boone, yes, ma'am. And I want to ask about these whenever you have a moment, referring to her written notes with questions. And she patted them to like emphasize that she had a list of notes. Detective, sure, detective. So obviously we received his autopsy. So this is an error, typo. We received his autopsy. So I'm going to read you your rights again because we have to talk about that. And he's underscoring, we have to talk about that. Mind you, the state has already responded to this. He's refined it to add in citations, but I don't see the specific citations. I just see like the constitutional. Anyway, he didn't address anything that the state said. We're not done talking about the incident. We just have to do it. Sarah, just like we did yesterday, normal protocol. Detective, just like we did yesterday. Remember, I read you the rights. Yeah, it's the exact same thing, but since I'm asking you follow-up questions, I need to read them to you, okay? So you have the right to remain silent. You guys know. Has anyone threatened you or promised you anything to get you to talk to me? No. And so do you understand what I just read you? Yes. Perfect. Okay. Full stop. If she understood she had the right to remain silent. So this morning we went to his autopsy and we were informed of some injuries. Okay. The interrogation continued for approximately 2 hours. At the end, while still in the interrogation room, the defendant was placed in handcuffs and arrested. The detective read the defendant her Miranda rights directly from the printed card at the OCSO. The detective omitted the final question printed on the standardized Miranda card of the Orange County Sheriff. The detective omitted the same Miranda rights question that she omitted the day before. The omitted final Miranda rights question is, having these rights in mind, do you wish to talk to us now? The defense has yet to receive a true and accurate copy of the card. Upon information and belief, it would look something like this. So they're arguing that she omitted something that on a card they haven't even seen. Based on all the circumstances surrounding the interrogation, the defendant's statement was coerced and not freely involuntary, given the defendant did not freely and knowingly waive her rights under Miranda. As such, the entire 2-hour investigation should be suppressed. Wherefore, the defendant requests that pursuant to Rule 3.190, Florida Rules of Criminal Procedure, the Fifth and Sixth Amendments of the United States Constitution, and Article 1, Section 9 of the Florida Constitution. So he did not cite a single case. State v. somebody, somebody v. state, 3rd District Court of Appeals, 5th District Court of Appeals. None of that. None of that. I now certify that I electronically filed the proceedings. So this is signed by James Owens. It doesn't give any, I electronically filed the proceedings by using the e-portal, which I understand will send a note. Okay, so he e-filed it. I am just like gobsmacked. Like he also has balls of a burglar. No wonder they get along together. I also feel like based on whatever he filed that caused the state to ask for the protective order, he's trying to get the state to request a continuance, right? He's trying to get them to request a continuance by overloading them with work. But if we didn't have Mr. J, some other, junior ASA might be running around trying to get the discovery that he's asking for that he is not entitled to. So I'm sure these are all appropriate legal activities. I just feel like he's riding that line of like what's ethical and what's not ethical, just in the wording and the approach, and the fact that he didn't get this in until today. He had time to do 3 media interviews on Friday, but not to abide by the judge's order. And I bet you he's going to play the word game and come back and say, oh, Judge, I thought you meant that if we were going to write a new motion of suppression for the body cam footage and for the 911 body cam and the audio recording of Sarah in the car, that I needed to file it by 11:59. I didn't know you didn't mean for me to amend this, right? Because he's not saying he's amended it in response to the state's rebuttal. He's just saying it's been amended. I'm going to show you guys this real quick. And then I got to get out of here because I got to get my bear. Let's share this tab. Let's make it large. Okay. So he was supposed to file the suppression request for Deputy Kayla Rodriguez and Detective Copsell and Lowen's conversations with Sarah on the 24th. Here's what the court said. Per the court, the defense must file motion to suppress by end of today, 11:59 p.m., 9/27/2024. The court will rule on defense motion as it relates to hair and makeup in chambers. This is where I got that from. Some people were saying, no, he's not going to do it in chambers. He's going to do it at the hearing. Well, all I have to say to that is this is what Judge Kraynick said. So if you're telling me what he said is not what he's going to do, okay. I didn't even show you guys. Oh my God, let me do this again. Okay. There we go. The defense must file motion to suppress by end of today, 11:59 p.m., 9/27. The court will rule on defense motion as it relates to hair and makeup in chambers. So that is what is going on. Like, I read the state's response on Friday. He didn't address any of their concerns, like citations, the actual Brady card. So we'll see. We will see. All right, because I gotta go get my baby. I want my baby back.